In a 4-3 vote, the Colorado Supreme Court rejected the Douglas County Schools Vouchers program based on the Blaine Amendment, which bans the use of public funds for religious schools. Program supporters hope to get the case heard in the U.S. Supreme Court because similar Blaine amendments exist and affect 37 other states. David, you're one of our two esteemed attorneys at the table, so I'm going to hand it directly off to you. What does this decision mean? What does it mean for Douglas County?
It's a split decision of the four justices who voted to strike down the Douglas County program. Three of them, as you said, voted on the basis of our Blaine Amendment, but that's only a plurality and it doesn't set precedent. The fourth vote was provided by Justice Marquez, our newest justice, in what I thought was a very powerful opinion, saying we don't even need to get to the Constitution because the structure of the program violates the Colorado School Finance Act. The other six justices said no, nobody has standing to challenge that, but she got to that issue. And I'm not an expert on that topic, but I think she made some powerful arguments. The plurality that relied on the Blaine Amendment had a much more difficult time because that amendment, which part of our original Constitution, which says you can't give government aid to religious institutions, including religious schools. The other argument is, well, we're not aiding religious schools. We're giving just people a scholarship, which they can take to a religious or non-religious school, whatever. And the Colorado Supreme Court had upheld a very similar program for college education. What we have, if you're a Colorado resident, you get a voucher that you can take to CU or Regis or whatever. And the plurality's attempt to distinguish that were very far-fetched and hard-working, and I feel sorry for whoever had to write that part of the unpersuasive opinion. Justice Ide, with two other justices, said that they should follow the original, the college analogy, and besides that, there is some question about whether the Blaine Amendment, which certainly had anti-Catholic animus as at least a very important motivation, is constitutional under the United States First Amendment's prohibitions on discrimination, even on neutral laws that are written in a neutral way, but which are written so as to target a particular religious group. The most recent case being one where the Santeria religion in Florida was targeted by a city statute for their animal sacrifice. Even though the statute didn't say "we hate Santeria," you could certainly read that between the lines of what had happened.
Penn, what do you think? Like I said, you're one of our two esteemed lawyers at the table. Some supporters are talking about, say, this can be our case for the U.S. Supreme Court about Blaine amendments. Is that wishful thinking? Does it end here? Where are you at?
I wouldn't call it wishful in terms of fantasy, but it's hopeful thinking. I think a number of people believe that one of the core issues in this case is you've got the state Supreme Court ruling on the validity of a program based on Colorado constitutional provisions in Colorado law. And it is not that usual for the U.S. Supreme Court to take a case and interpret for itself how state laws or a state constitution should be read, applied, and interpreted. That's usually deferred to the state. So I think moving this into the federal court system is a bit of a reach. The other thing that I think makes this case a bit difficult for the proponents of the program is the way Douglas County structured their program. Although they may argue with a straight face that it wasn't an intent to support religious institutions, they really structured it so that the majority of the schools that are qualified to receive these vouchers are religiously based and affiliated, and almost all of the high schools that have been approved under their program have a religious base to them. And the schools were given the ability to discriminate among school applicants based on those faith-based principles. And I think a number of people at their core say this may not be anti-Catholic or anything else. The Constitution says what it says, and we don't want public funds to establish any religion, not just Catholicism or Protestant religion, but any religion. And so I think this is a tough case for Douglas County to get around, and I'm not convinced they have any recourse to the federal judiciary. I'm not convinced they'll take this case.
And what about the voucher argument here in Colorado? Does this decision stoke the fire? Does it damper the fire? Where are you at?
Well, as someone who is neither a lawyer nor esteemed, I'll just say that there has been very little talk of vouchers for the 9 years I've been in the State House. I know this is something that was very big around the mid-2000s time, but when Republicans couldn't even get it through their own caucus at that point, when they had control, I think enthusiasm really waned for it. You've seen a bill go through the last couple of years that is trying to give tax breaks to people who send their kids to private schools. Even that's not going anywhere. I don't know. I think with so much going on in the state, I don't know that there is going to be a cause celebre to take this up and make this a legislative rather than a judicial issue. I think they like the idea of doing it on a district-by-district basis, but I could be wrong. We'll see.
Patty, wrap it up for us.
Well, it's interesting that we kind of got sidetracked on the Blaine Amendment issue because there are other things not to like in this Douglas County voucher program. And Justice Marquez did point out another problem with it. So I think it'll be in a legal boondoggle for quite some time. And I think Ed's absolutely right. I think charters have kind of taken the fire away from vouchers. And that's certainly the direction a lot of public school districts are going in, setting up specialty schools.